Alors, m'appelle l'eau back. De ça. Good evening, ladies and gentlemen. I want to welcome you to Harry's show. And tonight, the topic will be the new labor issue by the United States President that is gonna change the 40 hours, and then they're gonna make you work as 32 hours, and after 32 hours, and the government, which is the president, wants to increase the rate and then reduce the hours on the week pay, which is 40 to 32. And now it will be equal to the same exact result. It's reduced the rate, it's reduced the hours, but it increased the rates. The formula is you have to have the 29,206, which is the minimum wage. The minimum wage at this time will be $25 if the law is passed the next 2 or 3 years. And then the maximum of hour will be $32 hours. Then for you to calculate overtime is gonna be the minimum wage, and the maximum of hours will be the 29 US 207 will be 32. And now, when the department wants to calculate overtime, or if any of the employer is to file in violation of the Fair Labor Standard Act of 1938, now it's going to be the Fair Labor Standard Act of 2026 or 27 or 28, whenever that the law is passed, he will be the minimum wage, which is the $25, and then the maximum of hours will be 32 hours, and then he will go in front of the federal judge, and that's how the law gonna be implemented. In other words, you have to have a minimum wage and the maximum of hours, and that's really equal to overtime. Now, to get to overtime, it's when now you find a company that find any of their employee who work 32 hours on the contract it's going to be 9 to 4 or 9 to 3, whatever that the 32 hours, if it's going to be 5 days or 4 days, whatever that have to add up to the 32 hours will be basically the 32 hours. To get to the 32 hours to calculate overtime, you will need to have the Department of Labor to conduct an audit and find the violations of the federal law. In other words, once the violation is established under 32 hours, for instance, and then now the Department of Labor will have to issue a violation notice to every victim in that company books to say, now you misclassify your worker. Instead of have them working 32 hours by paying Social Security taxes, you misclassify them by give them a 1099. And that's mean the employer failed to pay Social Security taxes under 32 hours, and that will be equal 6.2% for the employee and 1.45 for the employee, and then 6.2% for the employer or 1.45 for the employer. And then now that number will be calculated when that Department of Labor find those violations, and they will have to really bring that corporate officer in front of the Justice Department to fail to pay Social Security taxes or fail to provide health insurance or Social Security benefits to their employees who are employees. And that's what that enforcement will be now under 32 hours by misclassify the worker as independent contractor. And now there is a really way of that when this government really wants to implement the law and what they call by a federal agency. In other words, the U.S. Department of Labor and the IRS, because when the company sent the 1099 over to the IRS and then calculate all the taxes under W-3 and send the report over, therefore the 1099 is already in the employer's federal ID number, and then it's registered under Social Security of the employee or the independent contractor that was disqualified. So therefore, they have to have some type of income and expenses. In other words, when the employer sends the checks to the employee, and every 2 weeks, this is an expense to the employer. And then whenever the vendors are paying the employer, that is an income for the employer. And now you have to match the expense and the income to see the 1099 were on the book. And now only the taxpayer under the code of the law of 6103 I-1, which call, first we have to define the word liability. The word liability, it's something that every one of us will understand. When you buy something in accounts, you buy insurance. Insurance is an asset, but you buy a house. The house is an asset, but the mortgage that you have on the house is a liability because you have to pay it every year, every day, every month to really to pay that liability. It's really in your book. So in other words, when you're not paying payroll taxes, that's a liability from the employer that was owed to the employee. And that's what, since 1938, that they call it liability, the word's liability, and that's what's supposed to stick into your word. If you don't have a tax liability, therefore you cannot enforce anything In other words, the Department of Labor cannot goes to the judge to say, Judge, I need liability. The judge is not their job to calculate liability. The job of the judge is to enforce a probable cause. In other words, the liability is equal to probable cause. In other words, what's going to be enforced by the judge, it's called probable cause. So now let's define the words probable cause. A probable cause, it's something that you did that was not according to the law, that the department now has to really find that the probable cause before he goes into the agency. The agency has to get the probable cause. And Fair Labor Standard Act of 1938, the probable cause called the tax liability, and the tax liability, it's governed by two federal agencies. The one called the IRS, and then the others called the U.S. Department of Labor, and governed by the code called 1346B and the 2672 SE. So therefore, you have the law that has to be in the book. It's what they call the Federal Tort Claim Act of 1938, which governed by the federal and together with the district court. And to enforce that 1346B, which is the liability, so it's an enforcement mechanics that has to be taking place by a federal agency. And that's what we define the two federal agencies first. And now the employee or the independent contractor have to sign a consent with those two employees. And remember, when you get to the federal government, and that's what you said is a crime that's already, and the crime that's already, that's what it become a probable cause. And the crime now has to be defined and enforced. And then once you have to do that, the agency has to really work the mechanics, and they have to file an audit. And when that audit is established, now you have the victim call on the audit. And that's when now, if you want to make the government as the plaintiff and the government as a defendant, that's when the formulas come into place. And that's how it works. Basically, when the liability is established, then the U.S. Department of Labor has to really send letter to all the victims and first have them to sign a consent. And that consent has to come in the summons and complaint. That's the first step. Now, the second step is the fact that the 1099 was already issued in behalf of all those independent contractors for the last 3 years. So therefore, now the IRS has to share the information with the U.S. Department of Labor to say now you have a consent for them to change the 1099 to become a W-2 form. And that's when the process just began. Now, from the IRS part, the U.S. Attorney General have to sign another consent for them to really bring the corporate officer in front of the judge to be arrested as the corporate officer who really have the money, because that corporate officer did not pay Social Security taxes in behalf of all those people that were victim, or all those employees, or all those 1099 that were actually in the book and not recorded as W-2 form. Now, it was recorded as a 1099. Now, the third part, it's the U.S. Department, the Attorney General that has to really sign those consent to bring the corporate officer in the front of the Justice Department, and that's called, on the IRS code, they call them the disclosure law. In other words, the disclosure law means you cannot disclose name, social security. As you know, last time I went over Congress, the House representative and the IRS that say Elon Musk cannot have access under DOJ employee of the federal government their personal information to send letters to them to fire them. So it's the same thing now. The Attorney General, the attorney who represent the plaintiff cannot have access to the federal social security, the federal ID number or the social security of the corporate officer in whom that they goes directly in front of the judge to say that person is committed a crime because there was no probable cause. So I'm going to come to that because I'm going to go for an example of how the law is applied and broken and how the scheme works. So now the third part, it's the U.S. Attorney General's office, and the IRS has to do an ex parte motion to bring the corporate officer in front of the judge to be arrested. But the process has to be tangled by three of those branches of the federal government, and the judge, it's really filed under the Justice Department. So now let's go to the motions. First, we filed a probable cause. You cannot arrest the corporate officer. In other words, there are no tax liability to say this man is violate the Fair Labor Standards Act of 1938 because therefore there is no probable cause. That's a violation of the 14 amendments because you have to have a due process. It's like making someone work and then you don't pay them the minimum wage, you don't pay them the maximum of hours, therefore you cannot calculate overtime. Therefore, you can't have the corporate officer to say, well, your company and you violate the Fair Labor Standards Act. That's not what the judges on the book law said. So now the process has to really, in effect, preciously get to the soul of the mechanics in which that the law is supposed to be applied. Think about it. We see a law, it's in the book, and since 1938, that the law has been practiced the wrong way. And we have a senator in 1945 that said the law is a scheme because he was thinking as an attorney instead of a CPA or an accountant. Because of the fact that the liability is the sole crime that was exactly committed, then that liability now has to be changed to really send the money back in behalf of all the victims, to really have the corporate officer where under the SS4, where the corporate officer, when the profit of the corporation is made, that's what he will take it under Social Security. Because when you apply in front of the IRS, your Social Security is the beneficiary of the corporation if the corporation make a profit. So when you fail to pay Social Security taxes, that means the corporation make more money. In other words, you're not providing insurance in behalf of your employee. Therefore, you collude, and then you collude. You not provide health insurance for the Social Security on behalf of your employee. So now let's take the process as a whole. The U.S. Department of Labor, the IRS, who deals to put an ex parte motion to have the corporate officer to be arrested together with the consent under the Attorney General. Now, the Attorney General is the one that had to change the 1099 to become a W-2 form. Now, the judge's job is to send the corporate officer to 6 months in jail and pay restitutions. So, therefore, it's a one-shot deal. It's A, B, C, D. A, Department of Labor. B, the IRS. C, the U.S. Attorney General's office really have to get the corporate and the FBI to be involved. And then the judge is to take the money, and the Department of Labor have to write a check now to whatever that the total is between the liquidated damage and the portion of the employer, and now the employer will pay the portion, the behalf of the employer, and the both portions have to be paid by the employer, and then send the checks now to the Treasury Department. So now the coordination between the IRS and the Department of Labor, now when the claimants or the victim get to be 65, that's when they will see that money into their account that was not paid. Now they're gonna have the account to be credited to pay Social Security benefits. And I went over the law multiple times. And now let's take the scenario where there was no tax liability. Now the attorney wants to really have the judge violate what they call by the corporate disclosure law called the 6103 I-1. We knew the law already, how the mechanics supposed to work. He called the 29 USC 216B. And then the 216B under our S code, they have four of them. Under the U.S. Department of Labor, the 29 216 mean that the victim has to become a plaintiff. So if you have 350 victim, you have 350 consents under 216B by the Department of Labor. Now you have 350 1099 that's going to be changed from W-2 form. Now you have to have 300 power of attorney by the U.S. Department of Labor, and that's what it becomes the United States, because all those four branch, or the two branch of the agency, the IRS and the U.S. Department of Labor and the Attorney General now, that's what makes it the United States versus the corporate officer. That's why you have to understand specifically what's the law under called the 1331, the U.S. 28 USC 1331. And that's what we have the judge, when it was confirmed, and the senators asked her, what do you have to do to be in the federal court? To be in the federal court doesn't hear cases. It hears cases who have federal questions. The federal questions mean you have to have a federal law, the treaty, and Congress. So you cannot be in the federal just for the heck of it. You have to follow cases that are controversial under state or who have a federal questions. The reason why this Fair Labor Standards Act goes to the federal and goes to the mechanics of the Federal Tort Claim Act, it's the fact that you have a federal questions. And the federal questions means that the Social Security benefits or the Social Security taxes of the insurance policy for those workers was actually violated. And that's what the violation of the liability now already has to take place. And that's what I want you to comprehend. So next step is, I want to give you, there are millions, I'm not talking on my behalf, Gale versus Harris Nurses Registry. I'm referring since 1938. There are millions cases that is in the system that is right now, that's violate the 14th Amendment, the 6th Amendment, and the 1st Amendments. And I'm going to give you my Gale versus Harris Nurses Registry. I will give you the case of Mario Batali on the 14th Amendments. And I will give you the case of Michael Jackson against his production company under 14th Amendment. That's violations. That's violate the 14th Amendment, because there was no probable cause to have a case number. That's violation established by the U.S. Attorney General's office. That's violate your probable cause. That's violate your constitutional right. That's called the due process of the law, because they could not establish the probable cause in order for them to get a case number. And that's what I'm going to go over again for you. They call that the law of disclosure. That's violated by the U.S. Attorney General, by the attorney who bring the case in front of the district court, the judge who are accepting the case, because the law was violations under disclosure law. Because if you don't have the plaintiff never give a consent or a power of attorney to the Attorney General's office to be prosecuted, or even to have the attorney for the plaintiff to really have the power to even bring a case, because there was no probable cause. And I will give you a case called Gell versus Harris Nurses Registry, that established on the district court on the Eastern District since 2007. They call it 11/7/2007. And there was no probable cause by the U.S. Attorney General. When I called, there was 2 indictment takes. One indictment took under the name of Harris Nurses Registry, but on behalf of the company called Levitt, David, and Moret. And those 3 attorneys that was in the company that time, they violate the 14 amendments and the 6 amendments and the First Amendment. And I'm going to go over it to you right now, because I got 3 cases that I'm going to illustrate. First, when you establish there is no probable cause, the U.S. Attorney General cannot issue an indictment into your name, because that's the violations point blank. You can't have to throw someone in jail without the liability, without the probable cause. So there was 2 indictments. One took under Harris Nurses Registry, and the other one took under Harry Dorvilier, and he was serving on the corporate officer and on the state where the corporate was registered on Albany, and that is where the violation is taking place. Because you cannot get an indictment where there was no tax liability on the Fair Labor Standards Act. So that means, being said, you can't say you violate the Fair Labor Standards Act. You cannot say that there was a violation on the state law of the on the minimum wage and maximum of hours, and you cannot say there was a violation on the unemployment insurance or the workman compensation, because there is a formula on the state. The formula on the state called the 29 U.S.C. 211B, and it's the same process, is the same audit that has to take place. Now, to switch it to the state attorney general's office, and the state attorney general's office has to take the same audit and then get to the enforcement for unemployment insurance and workman compensations. So now, when's that initiations of the violations of the 6103 I-1 that was initiated by the U.S. Attorney General? Now the plaintiff attorney, it's in bed with them because of the fact they cannot have a case number. If they have a case number, they have to have some type of relationship or power how to get a case without going to the process, because the power of attorney now has to giving to the Attorney General by the first plaintiff. And that's what the law started as a scheme because the Claudia girl, presumably to be a ghost. You know what a ghost means? A ghost means it's a make-believe names that orchestrated by the supervisor called Sherilyn West. Sherilyn West initiated the case where someone that's live in Georgia and she knows the license number. And then she took that license number and create Claudia Gale. And then she used the same license number and the address in Georgia, and the same address in Georgia that she reside, and then use the same license number and the P.O. box in Jamaica, the West Indies, and take the same license number with the names, have the attorney for the plaintiff sign what they call the agreements. If the attorney get overtime, he will get 1/3 from the whatever he recover on her behalf. And the same Sherilyn West took that name in upstate New York, which is 2 hours for her to receive her paycheck, and then she get the 3-4 paychecks from the address in Georgia, and now she get the rest of the checks from the address in upstate New York. And she's been the one to play the role of Claudia Gale. Now, all the nursing notes, all the timesheets, all the checks has been cashing to her, and she's the one who really goes to really get those information in the system. And when that is done, and before she left, now there was already an indictment talk on the U.S. Department on Harry's Nurses Registry name for Gail, that is the male plaintiff. Now, Gail said that she works for Harry's Nurses Registry, and Harry Dorvilier misclassified Gail by give Gail a 1099 instead of a W-2 form. But the Attorney General now were supposed to have Gail to give a power of attorney to him before to get a case number. So therefore, the attorney, those 3 attorneys who represent this law firm, Levitt and Moet, who get the indictment in their name, it's already violation on the 14th Amendment, the due process of the law, because there was no tax liability calculated for them to really, for Gail to sign a power of attorney against me, Harry Dorvilier, or against Harry's Nurses Registry, to have that called the probable cause to have both of us to be arrested and to be violate the law. So now the second step is the same attorney law bring the summons and complaints that's already established to the Eastern District and 225 Carmen Plaza to say it's a civil case. Remember, they said tax liability is criminal and civil. So as I define to you, there are 4 branches of the government to enforce that probable cause. Since you know the law already, now the law of disclosure, which in fact create in the attorney's mind to really do those cases, it's already premeditated crime because they are an officer of the court. Once you take that oath that you have to practice the law, or the judge or the attorney general's office take off at the office because they get paid by the taxpayers' money, it's there to really protect and defend us or defend the Constitution of the United States. You cannot violate the Constitution of the United States by your own citizen. That's what the law said. Before you get to the federal court, you cannot violate the law, the Constitution, and the treaty. So now, he took that indictment. When I called the 500 Pearl Street And the case number, they said this case number doesn't belong to your name, but is in the system in my name. Transfer the case now to the Eastern District in 225 Carmen Plaza. Now they said it's a civil case. Fighting the case since 2007, saying that the nurse were employee, and then there were 3 people that goes in front of the Judge Sifton. Anyway, how did the clerk now register the case with the summons and complaints who does not justify a violation on the Fair Labor Standards Act? And the code called the 281331, and the mechanics has to be done by the 4 branch of the agency. Therefore, there was something wrong. You cannot have a case number established until you meet all the 4 criteria from the Justice Department to the Department of Labor to the Attorney General's office to the Justice Department and the FBI to have your name to be into an indictment without the consent of the plaintiff, and the consent is a ghost. So now the case is already established, and they take the case in front of Judge Sifton, and then they have it in the magistrate Mata Zumato MG in November 7, 2007. And that's already established the violation of the 14 amendments. Now, I get the summons and complaint into the house, and they said, you have to return an attorney. And when I get to the attorney's office, I said, what is this client's name? And they said, it's Claudia Gale. I said, how much is the overtime she's looking for? And the attorney said, no, he's not settled the case. Because the crime is already there, because he's already knew what he's intended to do, because those crimes already meditated. And for me as an accountant who already understand the law, because I have an audit from the agency itself, that's called Miss Bell. Miss Bell in 1999 did an audit by the Department of Labor audit and said the nurses at Harry Nurses Registry were independent contractor because we don't control them. If we call them to work today, we don't call them tomorrow. They're not an employee because they have other jobs from different other places. So that means if the nursing will call me and they say, Harry, I need a shift to be complete, I send the nurse in and the nurse go to work. And then after that, we have no more relationship. And that's what Judge Bell said to the Department of Labor, that nurses at Harry's Nurses Registry is independent contract. Now let's go back to these cases. So, and I tell the attorney, if you want a returner, I'll give you a returner, but if the attorney for the plaintiff wants to settle the case, instead of give you $25,000 to get a returner, I better close the case and get it over. And the attorney said no, because he already have the crime premeditated in his mind, because it's already have a class action lawsuit on the Fair Labor Standards Act of 1938 by creating the ghost. So that law was actually, and then he copied, he actually now said you have to present on discovery in front of the judge to really make the 1099 to change to a W-2 form. Still, I have the discovery paper. The discovery paper is there to say, well, you could take summary judgment on the discovery against Harry's Dorvilier and Harry's Nurses Registry. But remember, the crime was already committed by those public officials that's already get a case number in the system against Harry's Nurses Registry and Harry Dorvilier. So now, discovery on the Fair Labor Standards Act, that does not exist. And that's what we still in the court today under 2025, because I never surrounded. Not only Judge Bell on the state saying the nurse were independent contractor, but the formula to change the 1099 to a W-2 form that have a mechanics has to be done. And that's what's done. That's called liability on the IRS and the Department of Labor and the Attorney General's office and the Justice Department. Now you see how the Justice Department and the IRS and the Department of Labor for million cases that violate the disclosure law by really penalize their own citizen because they violate the 14th Amendment of the constitutional right because of the fact the Fair Labor Standards Act, the purpose is to enforce a liability. And by the way, that's where what the word statute of limitations coming from. The word statute of limitations coming from a labor law. And it's when the Senator Daniel said that the law was a scheme and he wants to appeal the 216B, but he could not explain the 216B is a penalty section that only can be used by a federal agency. So now Congress come with a the law called Davis-Bacon law, and then bring Chapter 9 on the Fair Labor Standards Act. And the Chapter 9 said, if you don't have a liability, no federal judge, no state judge can calculate those liability, or no one can be penalized because there was no liability enforced. No state court, no federal court can penalize any of the citizen because of the tax liability. And now you have the statute of limitations called the 29 U.S. 255. And that's what the statute of limitation laws coming in. That's been after 3 years, you can't, if you have a tax return, you didn't file it, even though the government owe you $1 million, therefore you're gonna lose that million because you didn't file it with the statute of limitations. And that's what the statute of limitations says. If you have an enforcement mechanics, if you don't do it on time, statute of limitations come to the judge say, well, you didn't do it on time because you have 3 years to bring your case. And that's what the word statute of limitations coming from. And they call the 29 U.S. 255. So now let's go back again to the case of Gale versus Harris Nurses Registry. So after the discovery, now they want to take testimony for me. And I say, well, I will testify. And I testify that my nurses are independent contractor. If I don't have a job, I can send them to work. And then the Judge Bell said they are independent contractor to the state. So therefore, I'm exempt from the Fair Labor Standards Act. But I did not comprehend the federal law to the fullest of understand there is a tax loophole in the system that the judge and the attorneys and the Justice Department, they've been practicing in the wrong way. So therefore, I have to first go through the process of being the victim for me to go to law school and understand the mechanics of the accounting procedure and understand the law and understand what code that was supposed to be used. What is the formula for them to understand before they could get to the IRS code, to get to the Department of Justice code, because each one of them have certain code that you have to obey. But those code, there was never studied by the judge or never studied by the attorney, because it's a judge that become an attorney. So therefore, they always cited Court of Appeal, and this is the law. And the cases were cited by the attorney who present the summons and complaint, because in that summons and complaint, he copied from a federal agency that was already established the probable cause, which is the tax liability. Therefore, you cannot use a summons and complaint that's already used by the federal agency to say, no, that's justified the guilt of Harris Nurses Registry and Harry Dorvilier, or the guilt of Michael Jackson and his Michael Jackson production, or the guilt of the President of the United States because he issued a check to his attorney for $100,000, said he violated he's a criminal because he falsified the documents. That's where the the United States can put him to jail because he has a probable cause. So that's not exactly what the law said in the book. The law, it's just, the law is justified under code, not under Court of Appeal. Because when you use the Court of Appeal, remember the district court already do the mechanics. That's the mechanics. So if you're going to go to the district court, you have to get the department to go to the district court first. Or you cannot use those cases because they cannot be used as an example. And that's what you can't really have those judges that misinterpret the law to be used as the librarian for us to be an example for us to be followed. And that's what, no matter what, if the cases need to be to the Supreme Court on the consent, because the consent was already established under law by Senator Daniel and the Davis-Bacon law, because the judge said before you start your cases under district court, you need to have that consent. And that consent must sign by 4 branches of the agency: the Department of Labor, the IRS, and the Justice Department. Let's go back to Claudia Gale case. Claudia Gale case, not only he is not a real person, because you have to be a real person, that the role was played by Sherilyn West. Now is the attorney who has the big connections to the government that's really enforced. Because after the discovery, he copies 2 cases. One that was done in the Social Security benefits, and the other case was done by Superior Care, where there was, in the Second Circuit, there was an agency in the state of New York with 2 principals, and they were to jail for 6 months, and they were trading the nurses from New Jersey to New York. And that's what called the interstate commerce. And the department filed, the U.S. Department of Labor filed the violation and enforced those cases. Therefore, those cases cannot be used in Gale versus Harry, because Gale versus Harry is an enforcement. It's a scheme that's enforced, because when the judge gave the summary judgment, he violated the disclosure law by saying that the plaintiff attorney is looking for name, date of birth, Social Security for nurses from 2004 to 2009 and 2012. And it was 2009. From 2004 to 2009, the statute of limitation was overdue, and the case was no subject matter jurisdiction for the judge. That's called violation of the disclosure law against Harry's Nurses Registry and Harry Dorvilier. So do the nurse that the judge ordered me to give a list of 500 good nurses, good Social Security, with only a ghost that's in the summons and complaint saying that there was a dollar withdrawal under state law, and saying that the nurse is looking for the workman compensation under state law. That's a violation under ghost and a violation under state law, because unemployment insurance only can calculate under 29-11C. So now when the judge asked me to give those names to the attorney, and that's when the attorney has make his secretaries involved, said there was a violation here, that you can let me represent you, and all the statute of limitation claim that's already vanished, that doesn't mean anything. And then now the judge, the attorney, asked those 500 of my good nurses to come to his office and sign a consent to be a party on the class action lawsuit. And that's the violation of the 14 amendments and the violation of the state amendment, because as a defendant in the criminal case, Harris Nurses Registry and Harry Dorvilier have a right to confront his own victim, because there cannot be a plaintiff through the government, because the government's already violated the Constitution. The U.S. attorney violated the Constitution, the federal judge violated the Constitution, the district clerk that's give the cases violated the Constitution, the Miss Masamoto violated the 14th Amendment of the Constitution, because their job under Fair Labor Standard Act is not to have Harris Nurses Registry, an indictment that's already in my name without a probable cause. Is not the judge now to calculate, to force Harris Nurses Registry to surrender his names in the list of the nurses to the plaintiff attorney, because he has some connections. And the same connection now goes to Mr. Goen, because I did a pro se motion to say the judge misinterpret the law, because as Judge Bell said, the federal agency who already did the audit against Harry Dorvilier in 1999, the nurse were independent contractor. I wants to know now, when did the federal law change? And that's how, and when I do a federal taxes, I got to do the 1120S or 1065 or 1040 before I could transfer it to the 201. So therefore, the federal government cannot actually change the federal law unless it goes to the state, because the state in which where you reside, you practice, has to go first. And that's what, on the Medicaid side, the U.S. government give the money to the state, and that's why it becomes state funding to the help of the federal government. So therefore, the law of the state has to be respected first, because the nurse are an employee of the state under license. Since Claudia Gell did not originally have a license and doesn't reside in the state of New York, only Harris Nurses Registry does, they violate the state law by billing Medicaid to a license that doesn't belong to the plaintiff. And she get a paycheck through in a fraudulent way that Social Security doesn't belong to the name. And she filed bankruptcy 3 times, even though she doesn't exist. So it's all those really, in fact, plans to really get the cases going. So not only that, Mr. Goen, which is an affiliated to Mr. the continue of the scheme, now send to the state to have a prosecution, because the federal judge makes the nurse an employee under discovery. Remember, the law for you to bring the corporate officer in front of the Justice Department, the IRS have to do an ex parte motion under the federal ID number. And that's what the benefits under the SS4 has to go to your Social Security, because you are the beneficiary of that corporation. So therefore, if you want to produce a crime, because the indictment was already took in Harry Dorvilier and Harris Nurses Registry, now he sent a will endraftment to Mr. Brown and Queens DC's office to have Harry Dorvilier prosecuted, saying Harry Dorvilier did not pay workman compensation because the nurse were employee, because they were 1099. And the 1099, and George Tigland said, no, every 1099 in the book of Harris Nurses Registry do not have to pay unemployment insurance. They do not have to pay workman compensation, because they are independent contractor. And this is what you are. You are facing by someone who actually gets you harassments onto the federal code. And that's what you have by violated the disclosure law and the state law and the federal law, because the nurse were supposed to sign a power of attorney by the U.S. Department of Labor, Attorney General from the U.S. Department of Labor, and then the state of New York Attorney General to say they didn't have no workman compensation, to take the money and send it to the state on the same audit. And that's what you have the 229 US 211B is. So you can't not, you should not, you can't violate the disclosure law by the U.S. Attorney General. And that's what you have on the book for 1 million cases in the system since 1938. And I want you to understand the difference between when the violation of the Constitution and the law is implemented by the authority, because now those the authority that's really have a conflict of interest with someone that's contribute to their because of the fact they are friends with that individual, because that individual could preempted a crime in their mind and then put it on paper and then for them to go on the book with it. And that's what you have more than 1 million cases since 1938 in the book. So that's the violation of the Sixth Amendment. And not only that, now Claudia Gell gave 3 different addresses or 5 different addresses in the United States. She lived in 5 different states or have the 5 different way of scheming. Now she gave a driver license of Claudia Matias. The same Claudia Gell become Claudia Matias under 2 different names, 2 different license number. And now she has a license on the P.O. box in Jamaica, the West Indies. No I-9. Under the law, Sherilyn Williams only checked the criminality of Claudia Gell. But on the I-9, the employer have to make sure the Social Security belong to Claudia Gell. Now the same Claudia Gell now become Claudia Williams, where the attorney only represent Claudia Williams, but all the other nurses give a consent to Harry saying the money that Claudia Gell was supposed to be in fact received as the ghost. First, they give that's the funny thing. The first, after my pro se motion, it's very funny that the judge gave a summary judgment for Claudia Gell on the issue of liability and asked Harry Nurses Registry to give 500 nurses to the plaintiff attorney. Now, when the plaintiff attorney gets those 500 nurses, he called every nurses to sign a consent to become a party of the class action lawsuit. So now, I did a motion in August 18, 2009, and that was put in the garbage can because nobody wants to answer it because I said Claudia Gell doesn't exist in August 2009. Now, in 2010, Mr. Gowen sent my name to send the nurse to the district attorney saying the nurse didn't have workman compensation, and there was 400 and something thousand paid to all the 1099 that was never going to change. Now, they said Harry Dorvilier took the money and never paid workman compensation because the nurse were employee. But it's all make-believe because there was no actual 1099 to change to a W-2 form. It's just an harassment. That's basically the Sixth Amendment. And now, Claudia Gell Social Security in 2023, we have to explain how the scheme works, how she get to the name and don't have an I-9 and don't have a Social Security card. Therefore, she should not be able to work. Now the judge said, no, if you talk about Claudia Gell, about her and the law, you're going to be penalized $500 per day because you said that Social Security of Claudia Gell is a personal issue and suppose you cannot have access to them. But remember, Harry Nurses Registry is the employer and have a federal ID number, and Harry Dorvilier have a Social Security number. If Harry Nurses Registry misclassify the work, that's what the federal tort claim asks is the Department of Labor, which Ms. Bell, which already said the nurse was an independent contractor, would have get the same to really say the nurse were employee and have the money goes for unemployment insurance. Same Joyce Tigland said the same 1099, the money was supposed to come back to Harris Nurses Registry because the Department of Labor don't have jurisdiction over the money because they don't have to pay unemployment insurance nor the workman compensation. And that the funny thing is, when these cases come around, and many of the judges, when the district wants to really enforce the law, they say, get out of here in my case, because take $1 for workman compensation to stay to the state insurance is not a felony. And they dismiss the case on the day that the trial was supposed to say. And they are the same individual on the state insurance board that said the nurse were employee and then wants to do an audit to get more money for the nurses, start a case. The same judge said, no, you violated the law because the 1099 was not supposed to be unemployment taxes. It's everything is about the taxes. And if you don't understand it, that's what I'm conveying. I'm trying to express the end words to understand. Once the law is in the book, no state judge, no federal judge can change it. So everything else come after. Judges don't make law. The law is already established under law, and the Constitution's already established. The treaty, the law is being enacted by the House and the Senate and become law, signed by the president. So therefore, if you could do it to the president of the United States, so what about do you as the general public? So everyone have to understand what you in there for and why those things happen. And they're happening because of the fact everybody's looking for their own self. Because we pay the Attorney General our taxpayers' money. So therefore, if we don't pay Social Security tax, we don't pay state tax, we don't pay sales taxes, those income from the government will get to the government, and then now the same government that's really in the job use their favor to their friends by violate your constitutional right. And that's what slavery means. Because you have work and somebody really overseeing you can take your property without a due process. Because they violate your constitutional right and they violate your privacy. And you have to have a freedom of speech. And the 14th Amendment said you have to have the due process. And the 6th Amendment say you have to be able to confront your accuser, someone who accused you of a crime. So who accused me of a crime? Well, the 1099 cannot be changed as a W-2 form to make them an employee on the federal. So therefore, the form that was supposed to be established is already established in the 1099. And the state judge and the federal judge did not communicate because it's not the law. The federal is not communicate to the state, and that's what happened in the United States because the court is not communicating amongst themselves. And the books stay right there, and the judge make their own decision. Because the fact that it's the law, it's in the book, it's in the code, but it's not applied. Because the case goes for settlement or goes to the garbage can. And that's what the law is. Whomever can't really get the longest one to really litigate. And that's how you could see justice. Because the justice it's nice and sweet, but you're not going to see it right away. And that's what I give you the example of real person that's victim on the system. It's us. It is Michael Jackson. It's the president of the United States. It's me. It's Mario Batali who has 25 restaurants. The same attorney, the same law firm that's really sue Harris Nurses Registry and Harry Dorvilier is the same attorney, Levitt and Moret, that sue Pasta Resources and Mario Batali, who really close all these 25 restaurants. And he has to settle for $5 million because the judge said you have to submit all the name of the waitress and the busboy to the plaintiff attorney, then you could go make a settlement. Remember, the law said it's to pay Social Security taxes and pay unemployment and pay workman compensation. So therefore, they all are here. And we don't need to have a PhD. We don't need to write a thesis to understand those codes. Because those codes, the president just come with saying, I want to make the law 32 hours instead of 40s, but I only going to increase the rate of your pay. It will be end up to the same thing at the end of the day. So you have to understand there is a mechanics, and the law, when it's enacted, we don't want anybody to go by violate your constitutional rights, by violate your way of the law and the book, and because of someone has a friend of power, they could persecute you for no reason. And that reason is that they're not supposed to be there. And the case don't have no subject matter on the state. It doesn't have no subject matter on the federal, because Judge Tigland in 2007 said the Nurse Has Harry was independent contract. In 1999, they said the Nurse Has Harris was independent contractor. And nothing into the record to show that the summons and complaints or the indictments was justified, because they all was taken the back door unjustly, without me aware of the law. And that's what CNN could not believe in the Michael Jackson cases. They want to open the case, but they don't understand. The indictment was taken in one district, and then they go and sue him in another district. And that's what the court doesn't read among themselves. So since that indictment was already in his profile, they have to go and arrest him on the state to make him look very bad, and they find no probable cause because they find him not guilty. But remember, Johnny Cochran gave them $20 million settlements for the two kids that really accuse him of child molester. It has to be done by a federal agency or a state agency. And that's when they could bring Michael Jackson itself, not to a lawsuit, but to a criminal possession, if they find the child was not lying, just was motivated by greed, and their parents, that's really orchestrated to the Attorney General to get a case number against him to take his money. So those things are in the system. It is us to open our eyes to understand the law, then we could all be beneficial to our own destiny, to really know that the law, it's in the book. If it's misapplied or misclassified or misapplied, you have to bring awareness to the general public to know, hey, a federal question is the law, the Constitution, and the treaty. That's what brings you into the federal court. All case of controversial. If you don't have those type of those cases, you cannot make believe that a federal agency already did a case, then you could really take it to use it to your own citizen as a class action lawsuit. There is no such thing under federal law as a federal class action lawsuit. There is a mechanics to when a company misclassified the worker by not paying Social Security taxes, and that's what's called the Federal Tort Claim Act in 1938. So the book doesn't lie. And when Senator Daniel justified that error under 216B, but it was not an error, it's the mechanics that's called the procedure in which that the case has to be in the court. He could say that the law is unjust, or the law can only use as by a federal agency or by a state agency. That's what he said. No federal court, no state court, if you don't have a liability, can have you penalized for a tax liability, or you have to have a consent to be on the federal court before you start your case on the district court. Where was Claudia Gell's consent? Where was Claudia Gell's power of attorney to the Attorney General? Where was Claudia Gell's 1099 change to the W-2 form? So do all the 500 nurses that I give submitted to the attorney, the attorney to come to his office to have them say, the judge say he violated the Fair Labor Standards Act, therefore I need his money. And the money was never went to their beneficial. It only goes to the back door on behalf of the attorney who really wants to get the money on the settlement. And that's what they call the discovery on the Federal Tort Claim Acts. And think about it, million cases. So it's not one, it's not two, it's not three, it's not four, it's not five, it's 1 million. So how many victims that's really by the U.S. Attorney General's office and by the district court and all the United States court and all the 52 states. So you got to think about it. When the disclosure law violated by the authority, what is supposed to be the consequences are us as being the victim, including the President of the United States. And that's what he comprehends the law, and he really has to really do something about it. And so when the law has to be implemented or be used by a federal agency, therefore, it got to come with executive order. So we have to understand the Constitution, the 27th Amendment of the Constitution. So in Harry's Nurses Registry and Claudia Gell, the due process with the 6th Amendment was that the 14th Amendment was violated for the first one, and the Sims was violated by going to take the ghosts because they forced me to give the. Where do they get those nurses' consent to say they did not have workman compensation where the 1099 was already included into pay $428,000 in their behalf, everyone 1099, and that was paid by Harry's Nurses Registry because Harry Dorvilier, as the corporate officer, never really violated the law. But remember, the indictment was already taken on Harry Dorvilier's law, so there is no way they will back up on the case, and that's what the judge Joel Blumenthal, when every state judge said, "Get out of here in my courtroom," because take $1 for workman comp is not a felony, or it's not like a misdemeanor. And Judge Blumenthal said, "Coming with him, I bring him in for you. I bring him in." And because I refused to accept a misdemeanor because I knew the Fair Labor Standards Act, or the judge cannot change the 1099 to a W-2 form because I'm an accountant. I understand what they mean by 1099, but I did not understand the federal law at that time. So now I could teach you, I could explain it to you, I could touch it, I could feel it. So the same thing as you should be able to do, because accounting is a debit and a credit, and all it is nothing that's superficial that you could not understand. And that's what I make it clear for you, and the crystal clear in your plate, you could really eat it as we all to understand the world. It's not all the big stories, all the big code changes by the federal court or federal judge. Those are what they call by bluffing. That's what I call them. I said, "Sir, subject matter jurisdiction. You don't have jurisdiction over the issue. So therefore, you cannot litigate something that you don't have jurisdiction over a tax liability. Case closed. Therefore, you violate the disclosure law. And that disclosure law violates 3 parts of the Constitution. Under the Article 3 and Section 2, the Constitution, you have to have the law, the Constitution, and the case and controversial in order for you to see it in the federal court. What was Claudia Gell probable cause? Except her name and social security, she was not supposed to be in the United States because of the fact that the attorney who really have connections can make a class action lawsuit and his mind premeditated the crime. And the crime is still in the book after 17 years by harassing the whole system. And we have 2 Supreme Court cases, 1094 on the consent, because the Senator Daniel said you need to have a consent before you get to the court. So the same judge, Sifton, said you do not have a consent. And then the same consent now come to satisfaction of judgment because all the money was stolen by the attorney, because they go all to his pocket instead of going to Social Security benefits on behalf of the nurses. So therefore, that's what Johnny said: garbage in, garbage out. You doesn't have, it doesn't fit. We must so quick. So therefore, the law is a formula, sir. If there was no consent, you're not going to have satisfaction of judgment. That's what you keep saying. Claudia Gale, that's named Claudia Matias, and then named Claudia Williams. It still doesn't add up to the Social Security number because that person does not exist. I don't understand why you don't understand that. It's only you as an attorney and your mind that believe you could do a scheme in the system. Remember, the Social Security system was not started by you. It was started by the German. And the German and Europe copy from the system and bring it over here to the UK. So therefore, you cannot make numbers, or you cannot make believe that you could make a person, because your name and your date of birth have to go legally into the Social Security to make sure that that person that you're referring is you. And how come the only Claudia Gale only knows you, and you only one that can represent Claudia Gale? Why don't Claudia Gale represented by another attorney? Because you are the one who illustrates Claudia Gale. And Claudia Gale itself gives you the authority to pay different vendors for her. And who's that Claudia Gale? The first order was given in 12/23/2009. And at the end, for the satisfaction of judgment, you only say it's only have 3 orders, sir. There were 4 orders. One for 14, on 12/23/2010. One in 6/19, that's really give you the class action for all the nurses. That's mean you got the second order. The third order was 256, and the first order was 41. That's give you 931. So in that 931, you take almost 50% because you double deep. You know what that means? When you said the nurse is supposed to get, let's say, someone like Yolanda Robinson. She has a patient, 8 hours RN, 8 hours LPN, and you come determine that she get $210,000 for overtime. And that you give her $69,000, and then you kept the rest. Sir, you don't understand. Medicaid patient don't get paid overtime. Medicaid patient is like a Section 8. You can't change the law because you have a power with your friends into the federal government, or you have them into the state government. That's a violation of the 3 part of the Constitution: the 14th Amendment, the 6th Amendment, because the nurse did not sign a consent under HIPAA law for them, for you to have access to their name. That's violation of the disclosure law and the IRS code. That's a violation of the U.S. Department of Labor, because you're not supposed to be there because you premeditated the crime into your mind. It's a violation of the freedom of speech, freedom of religion, because I have the right to talk about a scheme that you are committed, and that's in the system since 2038. So think about it. If I did not explain it, if I didn't litigate it, Senator Daniel will not have a success story. So I have to continue by explaining to the general public how you as a genius under law can be caught. Think about it. It's like a fight between a CPA and an attorney as a jury. And the attorney thinks he knows the law, and the CPA knows his debit and the credit. And he understands his labor law. He understands his accounting. He understands Judge Bell. He understands Judge Sifton. Because we all are people of color, because we understand we have to follow the law. But we cannot do it in discovery, because the law in discovery doesn't justify that the 99 can be changed to a W-2 form. So you have to understand, if we are the one who violate the law, I will not be out now to communicate with you, because the government will penalize me 15 times than you do, who already premeditated the white-collar crime in your mind, because you have connections. So therefore, you have to understand, we are in the same, the 14th Amendment was created in slavery way. Though we need to understand that it still exists, because whenever you guys want to take someone their property, you find the probable cause to really take that in. And so you don't want the president of the United States to be president, you give him a profile. Say you give a check to your attorney, Cohen, $100,000. Therefore, it's a felony. It's the United States against you. Therefore, you got to go to jail or you cannot be president. I deny you the right, because, that's a violation of his constitutional right, because IRS can do that to him, because that's what he become the United States. There's 3-4 branches of the government to make sure come together to become the United States. And that's what the law is in the book is. You don't make law. You have to learn the perspective and to understand the House and the Senate, that's called Congress, and signed by the Vice President and the President of the United States. You have to understand the law already in the book. And that's what I would say. Good night, be well, and understand the law. It's a formula. And like your life, it's a formula. We have a great philosopher. He said, life, it's equal to H2O. We found the oxygen that we are breathing, H2, your body is composed of like 75 to 80% of water, and the rest is bone. So when that oxygen is stop penetrated to your lung, and the body goes away and the soul goes away, there will be no life. So therefore, without water, there is no life. Without the oxygen, O2, therefore, life is equal to H2O. So it's mathematics, it's physics, it's the world. So I want you to go back and understand the numbers don't lie. It's only you. When you think you are more superficial intelligence, AI, and the law, and that's how you get caught. So don't think your power of getting caught is not here. It's somebody who can comprehend, and therefore they can really make you believe to understand. And at least you have a professor who could really teach you the morality of do things the right way. Because if you think you could be the most intelligent people in the world by violating, take an oath on the Bible, say you're going to do an officer of the court, so you cannot be an example when you get caught. If you get caught, you got to penalize like everyone else. So good luck and be well. And I hope you enjoy the show.